Welcome everyone to Financial and Estate Literacy. We're going to have 6 weeks of information on estate planning, and this is our first session. The topic this morning is talking about kind of an overview, and we're going to have Blaine Searle is going to be our presenter. And so, Blaine, why don't you come up on the screen? How are you doing, Blaine?
I'm well. Thank you,
Good.
Peter, for this opportunity. And let me just jump right in and say, Peter, you and your team have been doing this for a very long time. And
Yeah.
this is a wonderful teaching tool for so many people. You've helped so many individuals. So thank you for doing this.
Oh, you're welcome. I enjoy doing them. We've been doing this since 1993. So, and we're trying to do it in a very safe environment where people can talk about death, can talk about taxes, talk about their estate planning and money, and not be jumped on to as far as selling them something. And so, Blaine, we're not paying you to be here. You're a volunteer. So we appreciate that. So why don't you pull up your Ask First form, and we'll introduce every speaker using their Ask First form. And by the way, Blaine's outline, his Ask First form is all online. So if you go to workshops, and click on that and scroll down to this presentation today, you'll see his Ask First form and his outline, and you can print that out. In addition, there are articles that are listed on the website as well that are pertinent to the topic that we're going to be talking about. So, Blaine, why don't you come back online, and we're going to go through this kind of orally together.
You got it.
And go ahead and share screen so
Yeah,
that
should be up right there.
okay. I just see your outline with your photo on top. Okay. Okay. You got a master's of other advanced degree. There you go. You got a master's of other advanced degree. What is that in?
Yeah, so I have, in addition to my JD, which allows me to practice law, I got a master's in tax law from Georgetown. So since I started my career, I specialize in anything tax related. So that involves transactional, but mostly estate planning, which is near and dear to my heart.
Okay. And then how long have you been in the practice of estate planning?
Almost 20 years now, believe it or not.
Yeah. And so why would that be important? Because you're a first presenter. So why can't somebody who practices corporate family law and something else also do your estate plan? Why would you want to go to somebody who just does estate planning?
Great question. I think the best way to answer that question is to tell you that within our firm, the fastest growing practice area in our firm is trust litigation. And I think that that's very telling because our trust litigation department loves LegalZoom. They love attorneys who maybe dabble in estate planning but don't do it full time. There's a lot that can go wrong in estate planning if you don't do it properly, and there are lots of really wonderful, good, qualified attorneys who specialize in estate planning, and it's worth it to go see one of those individuals.
Yeah. So talk a little bit about the firm, Ferruzza and Ferruzzo, are you all a national firm or?
We're not. We're have two offices, one here in Orange County and one in Texas that we're opening right now. But we're a full service law firm, so we have a transactional department that covers mergers, acquisitions, real estate. We have an employment law practices group, and we have a full litigation department as well.
And so how many people are in the estate planning department?
So in doing just estate planning, there are 5 of us. And then in addition to that, we have another 5 individuals who do probate, trust administration, and trust litigation.
Okay. So let's go to your credential licenses. Your license in the state of California,
And Arizona, correct.
and why is that important?
Well, because when you are talking to a professional about your estate plan, that is the practice of law. And you need to make sure that, California has very, very specific laws, as you might imagine. We in California love our laws, right? And so estate planning here in California is going to be very different from Texas or Colorado or anywhere else. So you have to make sure that you're dealing with somebody who's licensed, who knows the rules.
Okay, so being licensed in California doesn't give you the right to practice law in Texas, for example.
Correct.
And Texas law is totally different in the estate planning area than California is.
Yeah, that's right. And in fact, just right off the top, this is an introductory. So I'll tell you, California, as you and your viewers are aware, is a community property state. And there are only 13 community property states in the United States. And so, there's a really great chance that if you go to one of our neighbors, you're going to be in a separate property state, which has entirely different law that's going to govern it and will control your estate plan.
And while we're on the topic, because this is a kind of the introduction, if you have an estate plan done in California and you have property in other states, will other states recognize the California estate plan?
They will. There's actually a constitutional provision that requires them, not specific to estate plan, but contracts in general, to be enforceable from state to state, which is wonderful. But I throw out a caution, which is anytime that my clients decide to move to another location, right, outside of the state of California, I urge them to revise their estate planning documents to be specific to the state that they're moving to, because it's not just the trust, the power of attorney, the advanced healthcare directive. All of those documents are very, very state specific.
Yeah, and the other thing too is that you want your institutions to be familiar with the documents, and somebody maybe in Minnesota might not be familiar with a California trust, etc.
That's
So
right.
yeah, so
And heaven forbid you have to go to court and you've got a Minnesota attorney or a Minnesota judge trying to apply California law to a California
community property law, yeah,
yeah,
that wouldn't work.
no.
So you put your client's interest first, and you ask them to complete a retainer agreement with you. And so let's go to, how do you charge your clients?
So we will charge, for an introductory meeting, we typically charge half of our hourly rate, whatever the attorney's rate is for the initial consultation. We're big proponents when we're putting together what we call the basic estate plan, that we like to do that on a flat fee. And so if, we'll tell the client in the first meeting, depending on what their objectives are and the type of estate plan that makes the most sense for them, because there are a myriad different trusts to choose from. Once we pin that down, we'll give them a flat fee, and then we typically will roll that initial consultation fee into the flat fee, so you're not paying twice.
Okay, and then what are the hourly rates? Because not all attorneys are created equal. Some
Right.
of you have many more years of experience, others are beginning. What is the range of hourly fees at your firm?
Runs from 650 down to 400. My hourly rate is 575 an hour.
575 an hour. And then so half of that $575 an hour would be an introductory meeting with you.
That's right. And if they decide to go forward, then again, we roll that into the flat fee that we quote them.
Okay. And then let's say I'm going to give you an example, and you quote me an approximate fee just to give people a general awareness. I'm married. I have one child. I have one house, and I have $500,000 in an investment account that is outside of my retirement plan. Approximately, what would that cost?
Probably about $3,500.
About $3,500. And the documents that you have to draft, I'm assuming there's one living trust, and my wife and I each have to have a will. Each of us has to have a durable power of attorney, and each of us has to have an advanced healthcare directive. Is that?
That's correct.
That's correct. Okay.
And we'll talk about this actually today, what makes up an estate plan, but there are
Super.
some additional documents that would go along to be included in that package that you need for your
Okay. Are there any additional fees that I should be aware of?
Great question. So the only additional wouldn't be fees. Let's use the term costs. So there's some minor costs for photocopying, right? There's some costs that we have to pay to record a deed with a county recorder's office. And then some of my clients like to have a nice leather-bound binder to keep everything organized. It's about a $50 fee that we pass along or cost if our clients choose to go that route.
Is there any one state that's better to die in than another as far as cost is concerned?
Well, I mean, here's the good news. In the state of California, knock on wood, we don't have an estate tax that's state of California specific, right? So it's
Right.
not a bad state to die in. And in fact, we won't talk about this a whole lot, but we have this concept called a step up in income tax basis.
Yeah.
And maybe since we're doing introductory, let me just jump in and talk about why this is beneficial to die with community property assets, which is this concept of an income tax basis. If you buy a building, let's say a commercial building for $1 million, and that building appreciates to $4 million, if you sell that building, you're not going to pay tax on the full $4 million. You pay tax on the difference between your basis and the sale price. So in this case, the $3 million gain would be taxable. I bring this up to say that when you're in a community property state and one of the spouses passes away, all of the assets that are community property will receive a full step up in income tax basis. So for instance, if the surviving spouse sold that building after the first death, then she would have received a step up in income tax basis to 4 million, and she would have paid 0 income taxes. So if you're asking what state is good to die in, California ain't a bad state.
California is not a bad state to die in.
That's right. Plus, it's a lot easier to sprinkle your ashes in the ocean here than to transport them, right?
Right. Great explanation. Thanks so much for that. Who transfers the assets from the individual's name into the name of the trust? Who does that, and is there a cost to that?
Yeah, it's teamwork between us and the client. So we can handle certain things. For instance, deeds for real estate. We will prepare that as part of our package, right? And then again, the only additional cost would be the recording fee. So that will move your real estate into the trust. When it comes to bank accounts, generally speaking, we will give the client what's called a trust certificate, which is a certification of just the pages that are necessary for you to walk into the bank to open up a bank account or to move those bank accounts from your personal name and into your trust.
Okay. And then as part of, about how many hours do you spend with the client in this process of putting together an estate plan?
Great question. For me and for my colleagues, we prize highly education. And I mean that to say there are a lot of different trusts that people can choose from. And it's often the case that when someone comes into my office and says, I want you to take a look at my trust, I ask them, do you know what kind of trust that you have? And they generally have no idea. And so we try to take time to explain why the trusts work the way they do and to explain the different options that people can choose from. So our initial consultation can sometimes last 2 hours, right? Because there's a lot of time. And then to answer your question, once the drafts are circulated and we make and revise those changes, when the clients come back in, we also spend a lot of time going through each of the documents, explaining them, making changes if they want to make changes, and then signing in and talking to them about funding. So usually an hour and a half to 2 hours on the back end also.
Okay. Just would you give people an idea as to, the amount of time and effort that, I don't think you give away a toaster with your estate plan or, because people just get a bunch of documents,
Right.
and that's it. So will telephone calls, emails during this period of time, do you charge for those separately?
So generally speaking, if they're clarification, it is often the case when I meet with a client and I'll say, I need several names of successor trustees, whoever's going to take over afterwards. And oftentimes they don't know right then and there who they want to fill that role. And so they will then call us or give us an email, and these are the names, and I want to ask a question about somebody. We typically don't charge for those calls or those emails.
Yeah.
All included in the flat fee. Now, it is the case sometimes that clients will call and say, I know I told you I wanted to do X, but I've thought about it and I really want to do Y. Okay. And we may have already drafted the documents based on X. And so there could be additional costs or fees involved in revising those documents significantly to kind of encapsulate what they want.
But you let them know beforehand.
You do. That's right.
Okay. And then what if somebody has an estate plan drafted by another legal counsel, and they want to make a bunch of changes in that estate plan? Is that the same charge as drafting a brand new one?
Yeah, here's the interesting thing. These trusts are very, very long documents, right? As we've gotten later in years, if you look at trusts from the 1960s, they're like 10 pages.
Yeah.
And now if you look at trusts from the 2020s, you're looking at 90 pages. And the reason that they're growing is that we have word processing that makes it easy for us to throw everything in.
Yeah.
But it's growing because there are cases and laws that have developed over time that we're now including provisions in there as catch-all, as boilerplate to address these issues that pop up.
Yeah.
I highlight that to say, if somebody comes into my office and they have a trust drafted by someone else and they say, Blaine, I just want to change the trustee, we typically speaking won't do an amendment, just a simple amendment to that document. The reason being is that if I make an amendment to your trust and I just change this, I, as the lawyer, basically own the entire document, and I have an obligation to go through and tell you all the things that are wrong with that document.
Yeah.
Right.
Yeah. You're going to be held liable for the entire estate plan.
That's right.
So a lot of liability is built into the fees that you charge.
That's right. We're not being grabby. We're doing it, one, because we're using a document, and we'll typically amend and restate the document because it's one that's tried and true and that we know is good, and two, for that liability reason.
Yeah, so we're having an extensive conversation just on how Blaine and the firm charges their fees, and you need to understand that as well. Whomever you pick as legal counsel, what is involved? Are phone calls involved? Or if I call you and change my mind, and you really need to understand how you're being charged and what the fee. Do you get together with all the estate planning attorneys in Orange County and figure out what fees to charge?
We don't. What we try to do, and I encourage people, if they're cost conscious, to talk to lots of different people.
Yeah.
I think based on our fee, we fall squarely in the middle. There are firms who charge a lot more and firms who charge less, but we feel like we give good value for the cost that we're charging.
Exactly. So to check with others, and by the way, we'll ask every presenter the same questions, so you'll get a kind of a clue as to what attorneys charge and what an estate plan costs. The last question on the Ask First form is are you associated with anyone who sells annuities? And what I mean by that is receive fees for insurance, mutual funds, etc.
We are not. And under California law, actually, and this is a good point, which is if you're dealing with an attorney who is associated with any of those organizations, they have to disclose it to you in writing. But we've chosen not to because we see it as a conflict.
I think I agree with you 100%. If I had an attorney who disclosed that to me, I wouldn't go to that attorney.
Yeah.
So it's hard enough just to be focused in on the client and the estate planning. Okay, Blaine, thank you for a great introduction. Let's get into the program.
You got it. So we're going to jump back and forth here a little bit. Let me just make sure. Can you see my slides there?
Yes, I can.
Okay, and we'll jump back and forth here as we go through and talk about different topics here, and we'll skip all of this stuff. This is a quote that I always like to start with, And it's because it's Benjamin Franklin, who everybody loves Benjamin Franklin. And we always hear the end of it, but here's the full quote. Our new Constitution is now established. Everything seems to promise it will be durable, but in this world, nothing is certain except death and taxes. So I highlight that to say that, in this life, we all know that we're going to pass away, and we all know that taxes are a possibility. And so the sooner that we can, face that or wrap our arms around it or address that issue, the better that we can plan. Right?
10, 15 years ago, Blaine, when I first started, and I've been around a little longer than that, but it was all about taxes. I mean, your estate plan was to try to avoid the federal and estate gift taxes. Today, it's it's the rare individual that needs to worry about the estate taxes. What does that mean when you meet a client if taxes is not as big an issue as it was before?
Yeah, great question. And we're going to talk about taxes, and we're going to talk about how they're calculated. And we're going to talk about the numbers and to see whether it applies to you or not. As it turns out, if you own a house and you've owned it for a long time in California and it's a valuable asset, you may be in a taxable situation, but we'll talk about that.
Okay.
But the idea is this: as we sit down and we have these consultations with our clients, if we aren't concerned about taxes, then there are a whole bunch of advanced estate planning mechanisms or techniques that we just don't have to worry about. And we can really focus in instead on what are the things we're concerned about. Probate avoidance, which we'll talk about today, making sure that the assets go to the proper people at the proper time, which we'll talk about today, and making sure that you're benefiting your loved ones as you want to do so.
Let's get into the program.
All right. Good enough. Okay.
I know we're doing a little bit different than we used to do.
All right. We'll figure it out here. Okay. So when we talk about what is an estate plan, right? Because we hear that term a lot. What is an estate plan? Well, we're going to talk about specifics, but there are really two things that we're worrying about. One is to make sure that you and your spouse are cared for during incapacity. That's number one. And then number two, to make sure that after your death, that your assets go to the desired recipients in the proper manner. Okay, so I get this question all the time. What happens if I do nothing? Well, that is an option, as it turns out. You could do nothing. And as I tell my clients who are kind of vacillating between different choices, I tell them that doing nothing is a choice, right? Because if you choose to do nothing, you're deciding to instead let California intestacy law control. And so here, I'm just kind of a quick highlight. We're not going to spend a lot of time here, but it's talking about California intestacy law and what is going to happen and who it goes to. And so the question we get all the time is, well, everything is going to go to my spouse, right? And the answer is, in true lawyer fashion, it depends, right? It depends on if you have kids. It depends on if it's community versus separate property. A lot of things depend. And so we won't spend a lot of time focusing on that today. And these statutes and explanations are in the handout, and you can spend some more time and we can talk about that a little bit more.
But Blaine, you really have to figure out all the assets of the individual and how they have title.
Mm-hmm.
So it's in real estate, they always say location, location, location. When I think about estate planning, I think about title, title, title. How do you have title to your assets? And you probably, before you could do an estate plan, you have to figure that out for the client. And whether it's a house, whether it's a car, whether it's a brokerage firm, a bank account, insurance, how do they have title to their assets?
Right. And so I like to think of a trust like a box. And in that box, we're going to have all these wonderful instructions. But if it's an empty box, it doesn't do anyone any good, right? And so when you have that box, you need to open the lid and you have to put the assets into there. And so as we're having this conversation with the clients, the very first thing that we do is we give them a questionnaire and we ask them to fill it out. And my clients hate it because it's a lot of work, but it's a really good exercise because it forces the clients to figure out how they hold title to all of their assets. They're looking at bank account statements, right? Does it say my name individually, or does it say, the trust, me as the trustee of the trust? They're looking at brokerage accounts, right? They're looking at IRA and 401k beneficiary designations. They're looking at life insurance beneficiary designations. They're looking at real estate, and that's something that we can help with. We can pull title to that real estate because it's public record and confirm this is how it's owned, this is how it should be owned, right? And then there's all of the other things in life, right? With when we're talking about like ownership of closely held businesses. So we're going to look at that. How is it owned, and is it in the trust? So ultimately,
it's not easy,
not easy. And
easy.
It's a process.
Yeah. Sure. And also they need to know what the cost basis, what does cost basis mean?
Right. So this is a little bit like we talked about at the beginning of the presentation. Yeah. We talked about that building. So cost basis is initially what you paid for it. And so when you're looking at stocks, for instance, you may have stocks that have appreciated in value. So your basis is what you initially paid for it. And if you sell those shares of stock, you're paying tax on the gain. Cost basis in a house, again, what you paid for it. When you start talking about some other things, like maybe if you have investment property, your cost basis initially is what you paid for it, but you may have purchased that property to get some income tax deductions to depreciate that. And as you depreciate that, your cost basis goes down as you get those tax benefits. So it's a moving target. And sometimes nobody knows. And sometimes the accountant knows. And sometimes you're just grateful that you own it when you pass away because it gets stepped up and you don't have to worry about it anymore.
Yeah. But so one of the things that you need to know as well, besides the asset, the title, cost basis, what is the market value? Mm-hmm. So and we're going to talk a little about probate in just a little bit. And, does probate, well, I'm getting ahead of myself. Let's go back to your outline and we'll go through that.
You got it. Okay. So we're just going to jump through these things really quick here. This is talking about separate property, intestate share, so on and so forth, how they're received. And again, let me just spend just a couple of minutes on this here about the difference between community versus separate property, because this is a question we get all the time with our clients. We live in a community property state. And what that means then is that there's a presumption that all of the income that you receive as a married couple is community property assets. Okay, that's a presumption. Separate property assets would be assets that you brought with you into the marriage. They would be assets that you received by gift or inheritance during the marriage. Those would all be separate property. And in some cases, if you have a blended family, for instance, you may have a premarital agreement or a prenuptial agreement that kind of directs what those are and if it's going to stay separate or if it's going to become community or whatever the case may be. And again, that's important because as we talk about, when we're funding different sub-trusts or boxes that are created under the trust, we need to know if they're community versus separate. And again, it directs necessarily which of the assets are going to get a step up in income tax basis. So we can't tell you, as you give me your sheet and your questionnaire, I can't tell you whether it's a community or a separate. I can kind of hint to that, but that's ultimately a decision that the couples have to come back and agree and tell me that this is where we stand. Okay. I
love the what if I do nothing?
Yeah. So here's the takeaway. Unless you're comfortable going to court, and we're going to talk about probate, unless you're comfortable with the disposition that even though you have a spouse and you have children, you would presume that everything would go to the spouse, but that's not the case, right? So if you in fact really want your assets to go to your spouse, you have to look at something more than just the California intestacy law. And that's where we talk about the will as kind of the basic estate planning tool. Now, let's take a minute here and let's talk about wills. Because
what kind of wills are there?
Right. So there really kind of two kinds of wills. We call it a last will and testament, and then there's one called a holographic will. So a last will and testament would be a document that you type out and you sign, and California law requires you to have two independent witnesses who aren't named as beneficiaries or executors under that will to be a witness to that to make sure that it's valid. You also can write everything out by hand and sign it. It's called a holographic will. We as the attorneys, well, my trust litigation department loves holographic wills because, again, everybody fights about it. And there are all kinds of really interesting cases from law school about the miner who dies out in the wilderness and writes something down and sticks it in his can or something like that before he dies.
Howard Hughes.
Yes, Howard Hughes, that's right. So if you're going to rely upon a will is better than nothing.
Yes.
But my suggestion to you would be, make sure you at least comply with the basic California requirements to make sure that it's valid. Okay?
So when you do an estate plan for someone, you draft a will for them. And in the nomenclature in the estate planning world is that you do a pour over will. What is a pour over will?
Right. So one of the first objectives that we have in drafting a trust is we want to avoid probate at all costs, because there are lots of time, commitment, all the bad things that go along with probate. So we create this box of a trust and we put the assets in. But what happens if something gets left out? Here's the example where it comes up the most. You put your house into the trust and then you refinance your house. And the lender requires you to take it out of the trust and refinance it. And maybe you forget to put it back in. Okay. Happens more frequently than we care to admit.
Yes.
Well, if that's the case and somebody dies, they own an ownership interest in that property. We may be stuck in probate. So even if we have to go through all the mess of probate, we don't want to have a separate legal document that has all the rules and all the beneficiaries and so on and so forth. We want a document that gives us one beneficiary, and that one beneficiary is the trust. In other words, take all of those assets and, like a pitcher of water, pour it into the trust and let the trust do its thing.
And that's why they call it a pour over will. Is a will effective during your lifetime?
A will is not effective during your lifetime. It only comes into legal effect when you pass away.
And the hope is that we never have to use the will because we have all of our assets in the trust.
That's right.
Okay.
Yes.
By the way, if I move to Nevada, is Nevada a community property state? I don't know if they are or not.
I don't think that they are. Like I said, there are 13 of them, and I can't remember all of them right offhand.
I can't either.
One.
Yeah, I think that's probably a good Google question.
Yes, there you go.
Is Nevada a community property state?
Correct.
Okay, let's get back to your outline.
Okay, so let's just talk about why we maybe don't want to just exclusively rely upon a will. The will is a legal document. You're doing a couple of things. You're naming an executor. The executor is that poor person who has to step in and clean up your mess when you're gone, right?
It's kind of similar to the trustee in a trust.
It is. Yeah. Okay. So their job is to go to court, file the petition, and to lodge that will with the court. And then they get appointed and they have the legal authority to transfer those assets. That's what probate means, by the way, is a legal process by which you can move the assets from one person to another person who's entitled to receive it. Whether
change title, legally.
Title, that's right. So in that will, you're going to name the executor, and that's the person who's going to do the cleanup. California law will also require that person to post a bond, right, to make sure that they don't get away with any craziness. You can, and bonds are really crazy and can be very expensive. You can, in the will, waive that bond requirement. So you can just say, I want this person to serve without this bond. And then again, you can direct who you want to receive it and how you want to receive it. There is an exception that's important to point out to you under California law, and it's called the small estate affidavit. Here's how that works, and we use it all the time. If the entirety of the assets that are left by the decedent, if you add them all up together, and if the grand total is less than $184,500, then you can transfer assets with a small estate affidavit. So let me give you the best example.
Okay.
Even if we have a trust and we've put all of our assets in the trust, some of my clients like to keep a bank account out of the trust. Why? Well, they don't want a check that has the name of their full trust. They just want their names on it, right? And I say, okay, if you got to concede, you're going to do it, that's fine. But make sure that the value is less than $184,500. Because when they die, if the value is less than that amount, we can just give the bank the small estate affidavit and they'll just drop it right into the trust for us. If it's
Yeah.
more than that, then we have to probate all $184,600 or whatever the case may be.
I had a client who was $1 over,
Oh,
and Bank of America would not release the funds
right.
out of that checking account without a formal probate hearing. So it cost about an extra $10,000 to get that monies out of that account. And again, it has to do with title. If you have a bank account in your own name and it's over $184,500, you're going to go through probate.
Yeah. That's right. And this, by the way, is a good exercise. I get this question all the time, Peter. Somebody comes to me and says, I draft a trust for them, and they come back and they say, how often do I need to talk to you about it? And I tell them we need to revisit whenever there's a change in the tax law, whenever there's a change in the people who've named there, like a life event, birth, death, divorce, whatever the case may be. But I think every 5 years, it's a good idea to just take stock of the assets. What have I bought? What have I sold? To see, are we still concerned about this $184,500 number?
Let's go to the next slide.
You got it. Oh, one last point I want to bring up. The contents of your will are public. Okay, so if you've got a trust, you never go to court. It's all confidential. The only people who know about it are the heirs and the beneficiaries. But here, if you have a will, you're lodging it with the court. Everybody can see it. Everybody knows. So it's not great.
Yeah.
All right.
One of the ways, if you have a bank account, and we're going to talk about beneficiary designations in the retirement planning session, but we could talk just a little bit about it here. Banks have what's called paid on death. So you can go up to the bank teller and say, hey, upon my death, if I want the monies to go to my daughter, Jane. And that avoid the probate?
It does. Yeah. There are two types of accounts: POD, payable on death, what you just mentioned, or sometimes called TOD, transfer on death accounts. And there have been situations that we've had clients who've come to us and they said, listen, my mom just sold her house. She moved in with us. She doesn't have anything except this one bank account. And I say, okay, we still need the advanced healthcare directive. We still need the power of attorney, all of these things. What does mom want to do with the money? Oh, I'm the only child. She just wants it to go to me when I die. Maybe the answer is just as simple to go to the bank and say payable on death, and it automatically flows in. Now, it's not a foolproof mechanism. What happens if the person that you've named to receive that on death, what if they predecease you?
Yeah. Or
Well,
what happens
right
if
back in probate.
Yeah, or you get dementia and the beneficiary moves or something happens. It's PODs are great for small amounts of money.
That's right.
Don't make it your entire estate plan.
Right.
Okay. Are we ready to move on to the next document?
Let's do it. Let me just share one last thing here when we're talking about probate.
Okay. Oh yeah.
Really
The
quick.
cost.
Cost. It's crazy expensive, you guys. So
Yeah.
not only does it take a long time.
Yeah.
Before COVID, you could maybe knock out a probate in a year.
Yeah.
After COVID, the soonest is maybe a year and a half, maybe 2 years. They're
18 to
still
24.
backed up at the court.
18 to 24 months.
That's right.
Here in Orange County, anyway.
Right. And then here's the crazy thing. These attorney fees that you see on the screen here, these are what we call statutory fees. And what that means is it's written right in the statutes, and every attorney that you go to in California to handle will charge you the same fees. Now, if it's a lot of extra work, they may charge you extra fees too, but this is the minimum. And you can see the cost that we're talking about here. By the way, this is based on the value. So when you get a probate, you actually have to get somebody called a probate referee who's appointed, who values the assets, and they take a fee. And then the attorney and the executor each get the same fee here based on the statutory calculation. And here's the worst part. This fee is based on the gross estate, not the net estate, which means if you've got $1 million home with a $900,000 mortgage, we, the attorneys, get paid a percentage of $1 million, not a percentage of $100,000. So super ugly.
So, $1 million estate, if you consider court cost, attorney cost, fiduciary cost, it's close between $40,000 and $50,000.
That's right.
Yeah.
That's
So let's go to the next slide.
You got it. Okay, so the idea is, again, we've been priming this for the whole time, which is trust. And there are different parties to the trust. And I know you've got a whole
We got an hour and a half on trust, but yeah, but the point being though, I think in this estate planning course, there's a lot of new language. So, even when we have a trust, the executor is for a will, but you don't call in a trust the trustee the executor,
right?
Because you call him the trustee, the successor trustee.
That's
And so, and what do you call the person who puts everything into the trust?
Well, let's look at my slide. Here we go. So these are the parties: a settlor, a trustee, and a beneficiaries. So let's.
And they can all be the same person.
They can all be the same person. And in fact, while most people are alive, right, almost exclusively, with whether you're single, whether you're husband and wife, you are going to be the settlor. And those are the people who create it. You're going to be the trustee who manages it. You're going to be the beneficiary for whom you are managing it, right? So you get to wear all of these different hats depending on how you're looking at it. It all becomes really important once you pass away. And then there's some differentiation sometimes. But here's what we do. The settlor sets up the trust. It's a legal contract. It's notarized. It's going to identify all of the information and who you want to receive and how you want them to receive it. That's kind of the basics. And then we've talked a lot about this because it's so important, is the trust funding. You're going to have to go in and change title to bank accounts. You're going to have to record deeds to real property. You're going to have to assign tangible personal property into the trust. Here's a cool thing. Let me just take a little break here and talk about this, because this is so important, which is I get these little old ladies who come into my office. And years ago, they would come in and they'd say, I want to give this whole list of 100 items, watches and brooches and all of these things to specific nieces, nephews, grandsons, whatever the case may be. And so we draft the whole trust. And then they come back to me a month later and say, well, Johnny's not calling me anymore. He's out. He doesn't get the Rolex. Now it goes to Kimmy, right? And so I do a trust amendment and I change that. And I had a client, I kid you not, that came in and we had 5 trust amendments in the span of 6 months because she kept changing her mind. Here's the good news. California law says you don't have to do any of that. California law allows you to say in the trust document, hey, over here, I'm going to have a separate memorandum of tangible personal property. And I can change that as many times as I want, and I never have to go back and see my attorney. And so what you do is you keep it with your original estate planning documents when you die, and it will take effect. I want this person to get this watch. I want this person to get this diamond ring. And again, tear it up, make a new one. It's kind of a great thing to do.
Yeah, I always suggest at least that I ask the attorney to make the trustee the final arbitrator of personal property if the beneficiaries cannot figure it out. A lot of times personal property, that momentum of the watch or the painting causes a lot of friction in families. So you got to spend a little bit of time. One of the benefits of a trust, and it's certainly part of an estate plan, is that it can prevent a conservatorship. And talk a little bit about that. We're not going to go into a real amount of depth on conservatorship, but what is it, and why does a trust maybe prevent a conservatorship?
Great question. So sometimes when someone becomes incapacitated, for whatever reason, dementia, Alzheimer's, injury, whatever the case may be, they no longer have the capacity to make their own financial decisions. All right. So then you've got a couple of documents that you're going to rely upon to help. One is the trust. And the trust, remember that all of the assets are owned in the trust. And if that individual who is now incapacitated was the trustee of the trust is going to contain language, and it's going to give you criteria to say, if you have a letter from one doctor or 2 doctors who are opining that she or he can no longer handle their finances, then they step down or they're going to be removed, and you're going to have the next in line, the successor trustee, who's going to step in and do this. And they're going to manage the trust assets for the benefit of this person who's struggling. Okay. And so If the assets are in the trust, they can use those assets to care for the person. Well, what if the assets, or what if it's pertaining to something outside of the trust? Well, that's where the power of attorney kicks in. And the power of attorney, either a durable power of attorney or a springing power of attorney, you'll hear more about those in a future discussion. But that gives somebody the legal authority to step in and make financial decisions for everything outside the trust. Let me give you an example. Somebody opens up a fraudulent credit card in your name, and your spouse or your child calls the bank and says, this isn't valid. And they say, I'm sorry, I can't talk to you. I can only talk to him or her, the incapacitated person. You can give them that power of attorney, and that gives them the authority to handle those financial things.
You've mentioned a bunch of great stuff.
Yeah.
And one is this, whomever, if you get dementia or any kind of illness, or just want to resign, somebody has to have legal authority. And this is Orange County. I mean, we're a sophisticated community. We have lots of institutions. We're not Kansas. They're going to require you to have legal authority to handle somebody else's stuff. And so, we always talk about estate planning being for married couples. Boy, I tell you, for every single person out there, from my point of view, they need a living trust here in Orange County.
Right.
Because that successor trustee could step right in and handle your financial affairs. What does a conservatorship cost?
Right. Well, so let's talk about what a conservatorship is, right?
Okay.
So a conservatorship is if you don't have capacity and you own assets in your own name, right? Then someone has to go to court and get legally appointed to make financial or life healthcare decisions for you, right? If you've got a power of attorney or an advanced healthcare directive, you can almost always rely upon those to avoid that conservatorship process. It's timely, it's expensive, and the court oftentimes will give you kind of restricted power that you have to go back to the court to get approval to do certain things. So it's ugly. The initial process can run $15,000 to $20,000 for a conservatorship.
Yeah.
And just by having the trust, power of attorney, and the advanced healthcare directive, 99% of the time you avoid all of that.
Yeah, and exactly. So single people out there, consider this to be one of your most important documents. There's a question regarding co-executor or co-trustee. Would you recommend the co-situations in these legal documents?
Talk about a leading question. I can tell what you think about this, Peter. Legally, you're allowed to. Legally, you can do that. And it certainly makes sense if you're married, right? Co-trustees, absolutely. The question where it comes up, though, is I want to name my two kids because I don't want to show preference for one over the other. I want to make them co-trustees or co-powers of attorney. It's really challenging, you guys. Challenging for a couple of reasons. One is if you have co-trustees, what happens if they don't get along or they disagree, right? What are their options? What can they do? Well, you may have to go to court and get a court to step in and say, he wins or she wins, or this is what we're supposed to do. It's challenging as well with like a financial institution. And if you go to a financial institution or a hospital, if you have co-agents for medical and you say, I think we should take this tact or we should do this, the hospital or the bank, they're not going to do anything until they've spoken to both agents because they don't want to get sued. And what happens again if they don't agree? So yeah, I am not a big fan of co-agents, co-trustees, co-executors.
Yeah. Yeah. And the other thing too is this like, say, if you are an executor in the will, but you're not named as a successor trustee in the trust, does the executor have any power over assets, legal authority over trust assets?
No. And if we've got a pour over will, the executor is going to be there, and her or his role exclusively is to go and satisfy creditors. And then when it's done, to move those assets into the trust. They have no discretion to decide, I want these assets to go to these people, right? And so for that reason, Peter, we typically will name the same trust, successor trustees are the same as the executors under the will.
Because it's all about the money.
It's all about the money, and we're just going to move it from one box to the other. We want one person to control everything.
Can you have a power of attorney person, the attorney, in fact, change a distribution into trust?
Um, no, they cannot. It's an interesting question you ask. In theory, if you have someone who's incapacitated, California law allows a power of attorney under certain circumstances to change the trust, but it's really specific. You have to authorize them to do it. And I can't think of any great reason to do that. I would never put that in my documents.
No, I wouldn't either. Okay, so we talked a little bit about a trust. Well, let's go in just of what are the other two documents of a good estate plan?
All right. So let me jump ahead here because we've got a bunch of stuff in here about.
Yeah, go through the outline and a little bit, and we got the parties to the trust.
Yeah, so we got the trustee. We talked about that. The authority that the trustee has to manage those assets. They're bound by a fiduciary obligation. And what that means is that they have to put the beneficiary's interests first over their own interests. Trustees are allowed to take reasonable compensation, and it differs, what that amount is. That's a whole other conversation. But they have to put the interests of the beneficiaries before their own, a fiduciary obligation.
If they are both the beneficiary and the trustee, and there's more than one beneficiary, do they have to put their other beneficiaries' interests first before their own?
I suppose it depends a lot on the document, but generally speaking, if they're benefiting, if they have two beneficiaries and one of them is the trustee, they have to equally benefit the beneficiaries, right?
Okay.
They can't benefit themselves to the exclusion of the other person. And so, for instance, if we're dividing up assets, for instance, right? And we know that in the end, we want the assets to go 50-50 to one beneficiary and 50 to the other child, right? Two children. And one of them is serving as the trustee, which is super common. That trustee beneficiary can't have her pick of the litter first and just leave the dregs for the other child, right? They have to either agree, we're splitting this or whatever, or if they can't agree, you have to split every asset 50-50.
Yeah. And do you talk about with your clients as to who's going to serve as the executor, who's going to serve as the trustee, who's going to serve as the attorney, in fact, who's going to serve as the healthcare agent, and in each one of those roles, who's going to be your backups?
Yes.
In addition, and then do you talk about that they should do all of this for free?
So in our consultation that we talked about, and I said it's 2 hours, and this is one of the reasons that it's 2 hours, right? Is that we're in each and every document, we're running through a list of individuals who are going to fill those roles. So yes, it's an important part of the conversation. As far as compensation is concerned, it's an interesting question. So we do talk about compensation, and our trust does include a provision that talks about reasonable compensation. If we're talking about a trust company, right, generally in Orange County, they've got a kind of a staggered fee, right?
Yeah, and private professionals have a fee.
Private fiduciaries, that's right.
Yeah, and we're going to talk about that in the estate administration.
Right.
But I was thinking about family members, how does that work? I mean, if one member of the family charges, should that be known to the other family members that the parents want this one family member to be paid?
Sure. Well, it's certainly a provision in the document. And in fact, I just had a client yesterday who asked me to amend that provision to make it explicit, not only that they can get paid, but to make it explicit that they have the right to waive the fee. And I will tell you, when the kids come into our office after mom and dad have passed away, or mom has passed away, and they come into the office and they say, oh, I'm not going to take any fee. I'm just doing this because I love mom and I love the family. We tell them, okay, buckle up, write down your hours, because you're going to see here a year from now how much work you've put into this, and you need to be compensated for it. Yeah. Because it's a lot of work.
Yeah. Okay, let's go back to your outline.
Okay. All right, so we talked about the trustee. Beneficiaries. Okay, again, beneficiary is just a fancy name for saying the person who benefits or receives assets from the trust. While you're alive and you create your trust. You are the beneficiary. You can do whatever the heck you want with those assets. They're yours. When you pass away, the trust document is going to say, one, identify who the beneficiaries are, and two, it's going to identify how they're supposed to receive the asset. So we have tons of stories, in our practice here about, beneficiaries who at a young age receive a huge chunk of funds, and then lo and behold, they blow it, and how scary that is. So the first question I get when clients come into my office is, I want to stagger it. I want to have income at 30. I want to have half the principal at 35. I want to have all the principal at 40. And we talk about the pros and cons of that. And then we direct them to think about as well, based on the value of the estate, does it make sense instead to have a lifetime benefit trust for that trustee?
Yeah, because trust today is not about the taxes so much.
That's
It's
right.
about the family situation. How can we keep your family together? If you give a lump sum money to someone at 18 and never has to work again, that child is going to have a heck of a time being a responsible adult. I just,
Yeah. The key component that you said was wrong is that you give it to them at 18 and they'll never have to work again. The
yeah,
truth is they're going to have to start working a year later, right?
yeah, no, that's probably
18-year-olds
true.
aren't mature enough to handle this.
Yeah, but
I'm almost 50 and I'm not mature enough. So
yeah, yeah, exactly. I used to think 30 was mature, and now I'm thinking 50.
that's right. That's right.
But
All right.
we got kids who have special needs, and
Yeah.
there's all sorts of rules regarding that kind of a trust. We
Yeah.
have individuals out there that are alcoholics, and by the time we're 80, 90 years old and our kids are 40, 50, and 60, we know there are kids that are in troubled marriages.
Wow.
There are, and we say kids, they're 50, 60, and 70 years old.
Right.
So there's all sorts of family situations that maybe they're in the second, third, and fourth marriage that you need to know about, so you could set up an estate plan that fits and benefits the entire family.
Right. Here's the other thing that's interesting in connection with that is when you pass away, the two groups of people that are entitled to a copy of your trust are all of the beneficiaries that you've named in there and all of your heirs at law. And I bring that up to say, I very sadly occasionally have clients who come in and they say, I've got 3 kids, but Jimmy has been just a terrible person. We had a falling out years ago. He's mean. I don't
You
want to
haven't
give
seen
anything
him
to
for
Jimmy.
25 years.
Right. I'm going to cut him out. And I take off my lawyer hat and I put on my counselor hat and I talk to them and make sure that they've thought through it and that they want to do that. But I highlight to them and I tell them, just so you know, when you pass away, even though Jimmy is not named in your trust, he's going to get a copy of your trust and he's going to know that he's excluded from your trust. So you need to decide if you're comfortable with that. As we talk about these family situations, it's going to be public within your family, and you got to make sure that it creates the right messaging that you want.
Yeah. And again, we're not going to get into it today, but there's lots of things you can do to try to minimize the problems.
Right.
And sometimes there is no answer. Sometimes you kind of say, gosh, the family is so neurotic and there's so many individuals that want a piece of the pie. You may suggest you're going to end up more than likely in court, but at least you know that up front, and you can plan accordingly. Are we going to? We have 20 minutes, 15 to 20 minutes left.
Okay.
I want to make sure that we talk about the other documents in an estate plan, at least to give them the introduction.
Here it is.
Okay.
Ask and you shall receive. So we've talked about the pour over will, right, at length. We've talked about the power of attorney at length. Advanced healthcare directive. Again, you got a whole presentation, but just remember, this is a whole bunch of documents wrapped into one. If you have an old estate plan, it would be called maybe a healthcare power of attorney is what it was called. And this is about decisions for
Medical.
who's your agent for medical, and then end of life decisions, disposition of your body, all of those things wrapped into that document.
But on let's say somebody who doesn't have this document, and decisions have to be made whether or not to move you to a board and care, or to keep you at home, or any kind of personal type decisions. Who makes those if you don't have any documents?
It's a great question. There's the practical, and then there's the legal, which is practically, the kids are stepping in, and you may be lucky enough that mom goes along with it, and that the new facility is willing to accept that, but good luck with that, right? And so if you don't have that documentation in place, in some cases, you're looking at having to go to court, as we talked about, to get someone legally appointed to make those decisions.
Yeah, legal authority. And the
Right.
thing of it is, then you hope that your kids can work together.
Right.
So because it takes a lot of communication to help you. And if you have onset dementia, you may not be very cooperative.
That's very true.
What is HIPAA?
Yeah, the Health Insurance Portability Accountability Act. There seems like there's too many Y's in there, but this is the law that says that that hospitals and other medical providers aren't allowed to provide your protected medical information to other people, right? So this is what prevents Peter from walking into the hospital and asking for my medical chart. Which is a great law, and we love it and we need it. But the problem is, what happens if you're a family member and trying to care for somebody, and the hospital won't give you any information? You call the hospital and they won't tell you the condition of your loved one. So the idea here is that you'll have a separate standalone document, a HIPAA release, in other words, that says, I'm going to name the following individuals as agents, or as having the authority to obtain my confidential medical information. So as I say, this is anybody who you would want to be able to call the hospital to find out as to your condition.
Yeah.
So it's an important document.
The power of attorney, the advanced healthcare directive, the HIPAA, are those documents that go out of date, or they or if I did them once, they're good forever for the rest of my life?
Yeah, great question. All three of them are statutory forms. And again, what that means is that we literally pull the document from the statutes, and those statutes change from time to time, and they get updated. And even aside from that, assuming that the California law doesn't change those regularly, the Advanced Healthcare Directive maybe has a little bit of a longer life. But if you're talking about a durable power of attorney, I got to tell you, you're going to have a hard enough time, even with your statutory form, to get your bank to talk to you, because every bank, even though they're required to accept it because the statute says so, they all have their own form that they want, right? So if you have a power of attorney and it's older than 4 or 5 years, I call it a stale document. And
Yeah,
your
it's like
chances of
bread,
a financial institution accepting it are risky.
Yeah, yeah. And even medical doctors, if you have an older advanced healthcare directive, they go, hey, people change their mind. I think differently at 74 today than I did at 50. I'm much more aware that I'm approaching the shorter end of life, and my choices are now much different than I would at 50. And medical doctors and institutions recognize that. And so, you want to keep these documents updated. You don't want a stale document, even though legally they still might be good.
That's right. And it's also worth pointing out something different, or something additional, and that is to say, your Advanced Healthcare Directive, it covers everything from, I'm not feeling well, but I want somebody to make my medical decisions for me to help me, all the way, and then it jumps to the end of life decision, which is, if you are in a coma or a terminal medical condition and you have no brain function, this is what I want you to do with my body. There's a lot of stuff in between, guys, right? A lot of stuff between the point of no return, pull the plug, and I'm just doing a health, decision. And I bring this up to say that I tell my clients who are concerned about it, DNRs, they're concerned about breathing tubes. They're concerned about all these things, routine stuff that they need to talk to their doctor about a POLST. And that's an acronym. It stands for Physician's Order of Life Sustaining Treatment, a POLST.
Yeah, and we're going to be talking
Right.
about that in the advanced healthcare
Wonderful
session.
Add
And
it to your list. It's
no,
important.
no, no, great introduction to it because it's so important. If what happens a lot of times when we have these documents drafted and we go, gosh, I named Joe and Bill as my co-trustees, and Joe is left. Now I just want Bill. Can I just go back to my document and scratch out Joe's name?
You cannot. I actually just had a client who drafted his own trust amendment and notarized it and gave it to me for the first time. And I said, well, that's interesting. The answer is no. That's really dangerous, you guys.
Yeah.
Come back and see your attorney. We just charge like an hourly rate. I push my work down to my associates to draft it, and we just do an amendment to change that name.
Yeah. Even in your advanced healthcare directive, if you have a change, do a new one. And California Medical Association has forms. Attorneys have forms. There are statutory forms online. You can get a advanced healthcare directive new one through any hospital, but don't change things on a document because we don't know whether you made them, somebody else made them. In a trust, handwriting is not good most of the time.
Right. Never good. And powers of attorney have to be notarized, right? So when you make a change, is it valid? It's a mess. So it's great advice from Peter.
What in all of these documents, let's say you've been named, how do you resign? Let's say hey, I'm sorry, I don't want to be your agent for your healthcare, or I don't want to be your successor trustee. How does that work?
Well, the answer is you can just decline, right? And this is a question we get all the time with the trust. Just because you've named someone as a successor trustee doesn't mean that they're serving as successor trustee, right? So they actually have to accept that role. And some of them will write a letter and say, I don't want to have anything to do with this. I'm declining. And you can do the same thing with a power of attorney or an advanced healthcare directive.
Yeah. And that's why
it's important to talk to your people.
Yeah. You want 2 or 3 people.
Right.
So start thinking about individuals that you may want to name, and we'll have a whole session on estate administration.
And talk to them first to make sure they're willing to do it, right?
People have named me in their documents and never talked to me. So that's crazy. Let's go back to the list.
Oh, okay. Let's see if I can go back here one document. Let's see. Okay, well, I advanced the slide, but the list, the other 2 documents that it included were a deed, right? And we talked about transferring the deed over, and it was a memorandum of tangible personal property that we talked
about.
The assignment, right? Okay. The other thing, again, what we'll do is the way that we get all of your stuff, all of your artwork and couches and forks and baseball card collections and everything into the trust is we do it with an assignment or a bill of sale with just a single signature. We transfer everything over so that it's all in the trust.
Yeah, we've got 10 minutes left. We'd love for you to talk about the estate and gift taxes, and Prop 19, because Prop 19 is a major change.
Yes. Okay, so let's talk about estate taxes. Well, I got a slide here if I can get my mouse to work. Here we go. I'll tell you what, this new Zoom is a little tricky.
Yeah. You've been doing great, Blaine. I just want to let you know.
And okay, well, my cursor is not working. Let me just talk. Here we go.
Yeah.
Here's how estate taxes work. When you die, the IRS takes a snapshot of the value of all the assets that you own. And they compare that value. And by the way, to get that value, we got to go out and get appraisals. We got to get date of death values. We got to do all of this in order to figure out what the value of that estate is. There we go. And then the IRS compares that to the estate tax exemption that's in place as of the date of death. So if the exemption exceeds the value of your assets, you don't pay any federal estate taxes. And as we talked about before, there is no California estate tax yet, right? Just give them a few years. I'm sure we'll have one. But if your assets, you've done well for yourself and your assets exceeds the exemption, then you're entitled to the exemption, and anything above that is taxed at 40%. Okay. So right now, the estate tax exemption is $13,610,000 per person. That means if you've got a properly drafted trust and you do it the right way, you can take advantage, if you're a married person, of double that amount. So 27.22 million, right? And so a lot of you sitting in this meeting are like, doesn't matter. I'm so far from that. It doesn't ever matter, right? Next year, by the way, it's going to go up again. That's the way the law is currently written. But here's an interesting point, which is at the stroke of midnight on January 1st, 2026, the way the law is currently written, it's not going to require presidential or congressional approval. That exemption is automatically going to drop back down to $5 million per person, indexed for inflation from 2010 forward. So we don't know what the exact number is going to be, but we all estimate it's going to be between probably $7 and $8 million per person. So we go from 27 million down to maybe 14 or 15 million dollars. Okay. So you may think I don't have a problem at 27 million, but maybe when you take into account your house here and your second home in Palm Springs and your retirement account, maybe you're pushing up towards that number, right? The 14, 15, 16 million dollars. So as you're deciding what kind of a trust you want to use, keep that in mind. Now, Peter also asked me to talk about gift taxes and how that works. So the estate tax and the gift tax, they are what's called a unified credit. And in very simplistic terms, the math is really complicated. But in very simplistic terms, here's the way I would look at it. You've got your exemption, and you can either give it away during life and use a portion of your exemption, or you can die owning it and use your exemption. So if I've got $13.6 million and I give away $1 million to my children, my gift tax exemption, I don't pay any taxes, but my gift tax exemption drops by $1 million. And in very rough terms, that means that I have $1 million less to use when I pass away. Okay.
But I thought if I gave a gift over $18,000 a year, I would have to pay an income tax. I have to pay a gift tax.
Right. And not true, of course. And what Peter just highlighted is there's something called an annual exclusion number, and that's $18,000. And that means you can give $18,000 to as many different people as you want, whether they're your family members or your private fiduciary or your favorite attorney, right? We're always on the list. But you can give $18,000 and you don't ever have to file a gift tax return. But as soon as you give $18,001, you file a gift tax return, you don't pay any taxes. You just use up a portion of your gift tax exemption. If you gift everything, and this is what some of my uber wealthy clients are doing who've got, $100 million, we're giving away $27 million right now. We're going to use up all that exemption while we've got it. But for some of my more modest clients, in which I fall in that boat as well, right? I would never give away millions and millions of dollars if I only have, $4 million. It doesn't make sense. So
doesn't make sense.
Those assets, and but that's how the gift tax works.
Okay. Prop 19.
Prop 19. We
don't
can do
no
a
longer
presentation on Prop 19. Here's how it works. So Prop 19 addresses two primary issues. The first is, if you're 55 and older, do you have the ability to sell your residence and buy a replacement residence somewhere in California and transfer your exemption from the old house to the new house? The old rules used to be really, really tricky, right? And I won't even get into it. It depended on like which county you were buying in. It depended on if the new house was more expensive or less. All of that is out the window. Just understand that you have a lot of capability to do this, and it's a really great benefit. So if you're going to sell your house and you're going to downsize, or you're going to upsize at the beach by downsizing, right? Just know that you have the ability, at least in part, to transfer your exemption over. That's the good part of Prop 19. Let's talk about the bait and switch, which is the bad part of Prop 19. And that is, we used to have all of these great rules that made it possible for parents to transfer their home that they had owned and that the kids grew up in and was the family estate, right? Under Proposition 13 and Proposition 58, they had the ability to transfer that home to the kids, and the kids could inherit it and keep their parents' really low property tax base. And there were no restrictions on what they did with it. They could turn around and rent it out. They could live there. One of them could live there. All of them could live there, Brady Bunch style, whatever they wanted to do. No restrictions. Prop 19 came in and shot us in the foot on that. And what Prop 19 says is, To qualify for this exclusion, you got to meet a whole bunch of requirements. One is that it has to be the parent's principal residence. Number two is it has to become within 12 months the principal residence of one of the children. So if you've got 4 kids, only one of them has to move in, okay? If nobody moves in, you lose it, it gets reassessed. And then the next rule is there's this really complicated math where we have to look at and compare the property tax base to the fair market value, and the end result being that you may end up, even if it was mom and dad's principal residence, and even if somebody moves in, it may still get partially reassessed because the value of the house has gone up so far.
Yeah.
The last point is this. You used to be able to apply and use Proposition 58 for non-principal residences, right? Your house out in La Quinta, your investment property, you could pass it down to the kids and you had like $1 million of exemption that you could apply. That's all gone. So anything other than mom and dad's house, it's going to get fully reassessed. And I threw a little like asterisks there to say there are some slight, some mechanisms that we can use that are a little risky. If you want to take some chances, come and talk to us and we can talk about using an LLC to do some transfers. But Proposition 19, not a great law. So if somebody approaches you, in the grocery store and says, I want to sign this ballot to like modify Prop 19, keep the good stuff and get rid of the bad stuff, then you say, yes, please.
Yeah. The problem is that they don't separate the good and the bad.
Right.
They just want to throw out the whole thing. So,
Right.
we can talk a little bit more about that, but we're at 11:27. So, Blaine, super job. Thank you so much. Great overview. Well, one of the things that we haven't talked about is retirement plans, but we got an hour and a half on that. Some changes. Your beneficiary can't take a rollover or stretch it out over their lifetime. They now have to do it with 10 years. So we'll talk a little bit about that because that's going to affect some planning issues. Donations to charity organizations. For us who are 70 and a half and over, we should look at giving that from our IRA. And we're going to be talking about that under charitable opportunities. There's lots of changes there. So hopefully you'll stick around and watch the next 5 weeks of It's Your Estate. And we got through the technical part of it. And Blaine, you just did a super job. I wish we could all give you a hand.
Thank you. Thank you very much. It was
And if somebody has a personal question, can they email you your email address? Do you have a slide with your email address on?
I do. It's right. Let's see. I think it's right at the beginning. I think I've got my contact info or
right on the.
Yeah, it's right on the slide. Should be right on the slide.
It should be right on the slide. Yeah, IYME is where the outline is and his ask first form. So
good.
All right. Blaine, you have a good day and we'll take care. Eugene, any other questions that have come up that we need to address?
No, thank you so much for your time, Pete and Blaine. Appreciate your time. If anybody wants to see any of the slides or the blank ask first form, it is on IYME. Thank you, Pete, for directing everyone there. Again, thank you so much for your time. Have a good day.
Okay, take care. Bye-bye.
Bye.